Ever had that sinking feeling when you open your mailbox and find a stack of papers that could cost you more than your car? That's exactly what happened to me last Tuesday. Not a parking ticket, not a medical bill, but a $70,000 fine from my HOA for multiple covenant violations on property they never actually had jurisdiction over. What they didn't know was that I've spent 30 years mapping the Earth's surface for the U.S. Geological Survey, and when you mess with land boundaries, the Earth itself becomes your witness. Where are you watching from? Drop a comment below, because what you're about to hear isn't just another HOA horror story. It's a masterclass in how to use historical land records to dismantle bureaucratic tyranny. My name's Robert Rock Henderson, and I'm a retired geologist who spent his career mapping the Earth's surface for the U.S. Geological Survey. For the past 8 years, I've lived on a beautiful piece of land in the Cascade foothills of Washington state, where the mountains keep their secrets and the land tells its own story. I bought this property after retiring, not as an investment, but as a place to decompress from decades of fieldwork and actually put my knowledge to use on a small scale. When I first moved here, I didn't think much about the HOA. Most communities have them, and I figured it was just the usual nonsense about lawn height and mailbox styles. What I didn't realize was that Pine Ridge Estates wasn't your average homeowners association. It was run by a woman named Veronica Ronnie Shaw, who had turned HOA management into a full-time career, and a highly profitable one at that. Ronnie wasn't your typical HOA president. She wasn't some bored retiree looking for a hobby. She was a former real estate developer who'd seen the golden goose of HOA management and decided to cash in. She drove a white Mercedes SUV with custom HOA compliance decals, wore designer outdoor gear that cost more than my monthly mortgage payment, and had that particular brand of suburban entitlement that makes you want to check your wallet when she smiles at you. Ronnie's specialty was what she called community enhancement initiatives, which was really just a fancy way of saying she'd find any excuse to expand the HOA's territory, increase dues, and fine homeowners for the most ridiculous violations. She'd fined a family $850 for having a rock garden that violated natural aesthetic guidelines. She'd threatened to put a lien on a widow's home because her bird feeder was attracting excessive wildlife. One homeowner was charged $1,500 for excessive pine needle accumulation after a particularly windy autumn day. Never mind that the needles came from county-maintained trees along the public road. What made Ronnie particularly dangerous was that she'd married well. Her husband, Charles Shaw, was a county commissioner with significant influence over land use decisions. This meant that when Ronnie decided to push through questionable zoning changes or property modifications, she had someone in the commissioner's office making sure they happened quickly and quietly. Their power couple status made them virtually untouchable in our community, until they messed with the wrong person. I first noticed something was wrong about 9 months ago. I was conducting my regular property boundary check, a habit I'd developed from decades of fieldwork, when I noticed survey markers that didn't match my property deed. At first, I thought it might be a mistake, but after checking historical maps and county records, I realized the problem wasn't with my documentation. Someone had quietly moved the property lines. I followed the boundary markers upstream and found the source of the problem: new survey stakes placed right across what should have been my property line. The stakes weren't just marking a boundary, they were claiming my land as part of the HOA's common area. This wasn't just theft, it was cartographic vandalism. My property wasn't just my home, it was part of a historical land parcel that had been documented in federal surveys dating back to the 1800s. The boundary lines weren't arbitrary, they were based on natural landmarks and precise measurements that had stood the test of time. I contacted the county land office and was told that Ronnie had filed a boundary clarification request while I was away on a family trip. According to the paperwork, she'd claimed my property was part of the original development and had always been included in the HOA. What she didn't mention was that the clarification was actually a land grab designed to expand the HOA's territory and increase their dues base. When I confronted Ronnie, she smiled that sugary sweet smile she reserves for situations where she knows she's in the wrong, but thinks she can talk her way out of it. "Robert, honey," she said, "we're just making things consistent for the community. You should be grateful we're taking such good care of the property lines." Grateful? I was furious. This wasn't about community. This was about Ronnie using her position and connections to steal land that had been properly surveyed and documented long before Pine Ridge Estates even existed. I showed her the property deed that clearly documented my boundary lines. She barely glanced at it before dismissing my concerns with a wave of her hand. "Paperwork can be corrected, Robert. The survey markers are already in place. Why don't you just accept it and move on?" That's when I knew this wasn't going to be resolved through polite conversation. Ronnie operated on the assumption that most people would rather pay the fine or walk away than fight back. She had no idea who she was dealing with. I'm not a confrontational person by nature. I solve problems through data, documentation, and understanding the systems at play. That's what I do for a living, or rather, what I did for a living. For 30 years with the U.S. Geological Survey, I mapped the Earth's surface, documented natural boundaries, and helped resolve land disputes based on objective evidence. I know that land has memory. It follows the contours it's always followed, shaped by geological forces over millennia. You can redraw boundaries on paper, but you can't change the actual landscape. Most people in my position would have panicked. They would have hired an expensive lawyer and prepared for a long, drawn-out legal battle. But I knew something they didn't. When it comes to land boundaries in Washington state, the law is actually on my side, and I knew exactly how to use that to my advantage. I spent the next 48 hours doing what I do best, gathering data. I checked county records, pulled historical survey documentation, and measured the exact discrepancies between my property deed and the new survey markers. What I found was shocking. My property deed included boundary lines that dated back to 1902, lines that predated the HOA, the county's current zoning laws, and even the state of Washington's modern land management system. These boundaries weren't just a formality, they were legally binding and protected under both state and federal law. The documentation was impeccable: original land grants, survey maps, and decades of consistent use. But here's the kicker. Ronnie's boundary adjustment wasn't just illegal, it was geologically impossible. She'd tried to redraw the property lines to ignore a natural feature that had been documented in federal surveys for over a century, a glacial moraine that ran through the property. This moraine wasn't just a minor landscape feature, it was a significant geological formation that had been used as a boundary marker since the original federal surveys of the area. I contacted my friend Dr. Lena Martinez, who works for the Washington State Department of Natural Resources. Within an hour, she confirmed what I suspected. Ronnie's boundary adjustment violated multiple state and federal regulations, including the Washington State Boundary Act and the Federal Land Management Act. "Robert," Lena said, "this isn't just a property dispute. This is a serious boundary violation. Those moraines are protected natural features that can't be ignored when establishing property lines." I knew I had to act fast. The Weather Service was predicting heavy rains in 3 days, and Ronnie had scheduled an HOA board meeting to finalize the boundary clarification and impose fines for unauthorized use of common area. If I waited for the legal system to catch up, the damage could be irreversible. But I also knew that rushing into action without proper documentation would play right into Ronnie's hands. She'd been waiting for an opportunity to paint me as the unreasonable neighbor who destroyed community harmony. So I did what any good geologist would do. I started documenting everything. I set up time-lapse cameras at strategic points along the property line. I took precise measurements using my professional surveying equipment. I collected soil samples to document the geological features that define the boundary. I even brought in a drone to capture aerial footage of the entire property. Then I did something most people wouldn't think to do. I contacted every homeowner in the development whose properties were adjacent to mine. I showed them the historical survey maps, explained the geological significance of the boundary lines, and asked if they'd be willing to sign a petition demanding the boundary be restored to its original position. What I discovered was both surprising and encouraging. Almost every homeowner I spoke with had their own horror story about Ronnie's HOA tyranny. There was Mr. Jenkins, whose property she'd entered without permission to inspect his garden. There was Sarah Mitchell, who'd been fined $1,200 for having a native plant garden that violated landscape guidelines. There was even a retired surveyor who'd been threatened with legal action for questioning one of Ronnie's unilateral decisions. These weren't isolated incidents. They were part of a pattern of abuse that had been going on for years. And suddenly, everyone was willing to speak up. The fear that had kept them silent for so long was beginning to dissipate, replaced by a shared understanding that Ronnie's power only existed as long as people were willing to accept it. While I was building this coalition, Ronnie was busy playing the victim. She called an emergency HOA meeting and presented photos of my aggressive behavior near the survey markers. She told the gathered homeowners that I was a dangerous individual who was threatening the safety of our community. She even produced a doctored photo that made it look like I was tampering with the survey markers. The local news picked up the story, of course. Ronnie made sure of that. She appeared on the evening news wearing a concerned expression and talking about protecting our children from unpredictable neighbors. The reporter didn't bother to verify her claims or check the county records that clearly established my boundary lines. But here's what she didn't know. I'd been documenting everything from day one. I had time-stamped photos of the survey marker installation, copies of the county records showing my proper boundary lines, and even video of Ronnie admitting that the boundary adjustment was for community expansion. I also had detailed geological reports showing the significance of the glacial moraine that defined the boundary. I also knew something else that Ronnie didn't suspect. I'd discovered that her boundary adjustment wasn't the first time she'd pulled this stunt. A quick search through public records revealed that her previous HOA in Oregon had paid a $950,000 settlement after a similar boundary adjustment caused a property dispute that lasted for years. The details were eerily similar. A boundary clarification filed while homeowners were away, a hastily adjusted property line that ignored natural features, and a pattern of intimidation against anyone who questioned her authority. This wasn't just about my land. This was about stopping a pattern of behavior that had been hurting people for years. Ronnie wasn't just a bully. She was a repeat offender who had learned that most people would rather pay the fine or walk away than fight back. The morning after the HOA meeting, I received a letter from Ronnie's attorney. It was a cease and desist order demanding that I stop harassing HOA members and spreading false information about the community. It also threatened legal action if I didn't immediately stop my campaign of misinformation. The letter was full of legal jargon designed to intimidate, but it was completely baseless, the kind of thing Ronnie's attorney knew would scare most people into silence. Most people would have backed down at this point. But I wasn't most people. I'm a geologist who spent his career working with land boundaries that have existed for millennia. I know that the Earth itself provides the most reliable evidence, and no amount of legal threats can change that. I called Lena again. What happens, I asked, if the DNR confirms the violations, but Ronnie refuses to restore the boundary? Lena was quiet for a moment. In that case, she said, the state can order the boundary to be restored. But it takes time, usually weeks, sometimes months. If the HOA meeting happens before then, I knew what she was implying. If Ronnie pushed through the boundary adjustment at the HOA meeting, it could become much harder to reverse. And with the fines already looming, I needed to act quickly. But there was another option. The boundary line followed a natural glacial moraine that was documented in federal surveys. If I could demonstrate that the moraine was a protected natural feature, I might be able to force Ronnie's hand. I spent the next 24 hours studying the geological features of the boundary. It was a clear glacial moraine, a ridge of sediment deposited by a glacier thousands of years ago. This type of feature was well documented in federal surveys and protected under both state and federal law. But there was a problem. Ronnie's survey crew had placed new markers that ignored the moraine entirely, essentially pretending it didn't exist. This wasn't just negligence, it was a deliberate attempt to erase a significant geological feature from the property records. This was it. This was my leverage. I filed an amended complaint with the DNR, specifically highlighting the ignored glacial moraine as a violation of state boundary laws. I also contacted the Federal Bureau of Land Management, explaining the situation and emphasizing the historical significance of the boundary. By noon the next day, I had confirmation that the DNR would conduct an emergency inspection the following morning. The BLM had also agreed to attend, as had representatives from the county's land management office. Ronnie couldn't ignore this kind of official attention. Ronnie didn't take this news well. That afternoon, she showed up at my door with 2 HOA board members in tow. "Robert," she said, her voice dripping with false concern, "I'm worried about you. You've been acting so erratically lately. Maybe you should take some time to focus on your mental health." I smiled. "That's funny, Ronnie. I was just about to suggest the same thing to you. You know, after the DNR inspection tomorrow morning, you might want to start thinking about your legal liability for that illegal boundary adjustment of yours." Her face went pale. "You wouldn't dare!" "I already did," I said. "The inspection is scheduled for 9 a.m. tomorrow. I suggest you have your attorney there." As she turned to leave, she muttered, "You should have stayed closer to home, Robert." I called after her. "Funny you should say that, because I've been studying land boundaries for 30 years, and I know exactly what happens when you ignore the Earth's natural features." The next morning, the DNR inspection confirmed everything I'd suspected. The boundary adjustment had been made without the required permits, it violated multiple state regulations, and it ignored a protected natural feature. The DNR issued an emergency order requiring the boundary to be restored to its original position within 72 hours. Ronnie was apoplectic. She demanded to speak to the DNR director, threatened to sue the inspectors, and even tried to bribe them with offers of future cooperation. None of it worked. The inspectors were professionals who had seen this kind of behavior before. That afternoon, I received another call from Ronnie's attorney. This time, it wasn't a cease and desist order, it was a settlement offer. $350,000 to go away and not pursue further action against the HOA. I declined. 2 days later, with the 72-hour deadline approaching and no sign that Ronnie was going to comply with the DNR order, I did something that would change everything. I filed a motion with the county court requesting an emergency hearing to address the imminent boundary violation. The hearing was scheduled for the next morning, the same morning as the HOA meeting where Ronnie planned to finalize the boundary adjustment and impose the $70,000 fine. I knew what I was doing was risky, but I also knew that sometimes the only way to stop a bully is to stand your ground and force them to face the consequences of their actions. The courtroom was packed the next morning, not just with lawyers and officials, but with homeowners from the community, people who had been silenced by Ronnie's tyranny for years, but were now ready to speak up. There was Mr. Jenkins, who had kept detailed records of every time Ronnie had violated his privacy. There was Sarah Mitchell, who had photographs of her native plant garden before Ronnie had forced her to remove it. There was even the retired surveyor, who had brought a file of legal precedents showing how Ronnie had repeatedly overstepped her authority. Ronnie arrived with her usual entourage, her husband Charles, 2 high-priced attorneys, and a team of experts who were clearly on her payroll. She was wearing a designer outfit and pearls, looking every bit the concerned community leader. But her eyes kept darting around the room, clearly unnerved by the number of people who had shown up to support me. I showed up in my work clothes, khakis and a button-down shirt, the same outfit I wear when I'm out in the field studying land formations. Sometimes the best armor is just being comfortable in your own skin. The judge, a no-nonsense woman named Judge Margaret Collins, who had heard hundreds of property disputes in her career, wasted no time getting to the heart of the matter. "Mr. Henderson," she said, "you've alleged that the boundary adjustment made by the Pine Ridge Estates HOA creates an imminent violation of state and federal boundary laws. What evidence do you have to support this claim?" I stood up and presented my case methodically. Copies of the DNR inspection report, geological analysis of the glacial moraine boundary, historical survey maps showing the original boundary lines, testimonies from adjacent property owners, documentation of Ronnie's previous violations in Oregon, time-lapse footage of the survey marker installation, soil composition reports showing the geological significance of the boundary, detailed maps showing the impact of the boundary adjustment. Judge Collins reviewed the evidence carefully, her expression growing more serious with each document she examined. Then she turned to Ronnie's attorney. "And what does the HOA have to say about these allegations?" The attorney stood up and launched into a well-rehearsed speech about how the boundary adjustment was necessary for community consistency and how I was misrepresenting the facts to serve my own agenda. He presented photos of the new survey markers, calling them a beautiful addition to the community that provided clearer property lines for residents. He even produced a letter from a land management expert who claimed the boundary adjustment was completely valid. Judge Collins listened patiently, then asked a simple question. "Is the HOA in compliance with the DNR's emergency order?" The attorney hesitated. "Well, Your Honor, we're working on a solution, but—" "Are you in compliance or not?" Judge Collins interrupted. "No, Your Honor," the attorney admitted. "Then why haven't you restored the boundary as ordered?" The attorney launched into a complicated explanation about permits, surveying challenges, and community concerns. Judge Collins cut him off. "Let me be clear," she said. "This court will not tolerate willful violation of boundary regulations, especially when those violations create an imminent legal risk to the community. The DNR has determined that this boundary must be restored within 72 hours. If that doesn't happen, I will hold the HOA and its officers in contempt of court." She turned to me. "Mr. Henderson, is there anything else you'd like to add?" I stood up and said simply, "Your Honor, this isn't just about a boundary line. It's about respecting the natural order of things. This boundary has existed for over a century, defined by geological features that have been here for thousands of years. What the HOA has done isn't just illegal, it's disrespectful of the land and the people who depend on it. I'm not asking for special treatment, I'm asking for the law to be enforced, as it should be for everyone." Judge Collins nodded. "The court agrees. The DNR's order stands. The boundary must be restored to its original position within the 72-hour window. Failure to do so will result in contempt proceedings and potential personal liability for the HOA's officers." As we left the courtroom, Ronnie approached me, her face red with anger. "You've ruined everything," she hissed. "The HOA meeting is today, and now this!" I looked at her calmly. "You made your choices, Ronnie. You decided to break the law and steal land that wasn't yours. The consequences are on you, not me." That afternoon, as predicted, the Weather Service upgraded their forecast to include heavy rains overnight. By evening, the soil along the boundary line was already becoming unstable. I watched from my porch as Ronnie and her crew scrambled to prepare for the HOA meeting while also trying to figure out what to do about the boundary. They brought in survey equipment, tried to reposition the markers, and even considered canceling the meeting. But it was too late. The heavy rains were putting pressure on the soil, and without the proper boundary in place, it was only a matter of time before the land itself would correct the error. At 10:30 that night, with the rain coming down in sheets, I got a call from Lena. "Robert," she said, "the DNR just got a report that the soil instability along the boundary is causing property damage. We need to get the boundary restored immediately." I grabbed my emergency kit and started making calls. I contacted the county land office, the DNR, and every homeowner affected by the boundary adjustment. Within an hour, emergency crews were assessing the damage. By morning, the soil instability had caused minor damage to several properties along the adjusted boundary line. The new survey markers had shifted significantly, and the natural features that defined the original boundary were becoming more apparent as the soil eroded. The aftermath was swift and decisive. The county immediately launched an investigation into the boundary adjustment. The DNR filed civil charges against Ronnie and the HOA for boundary violations. The homeowners who had been affected filed a class action lawsuit seeking damages. But the most significant development came 2 days later when the Bureau of Land Management announced a federal investigation into potential fraud and corruption related to the boundary adjustment permits. Ronnie tried to spin the narrative, of course. She told the local news that the soil instability was an act of God and that I was exaggerating the situation to serve my own agenda. But the evidence was overwhelming. Photos showed the ignored glacial moraine. Geological reports confirmed the boundary violation, and multiple witnesses testified about Ronnie's pattern of abusive behavior. Within a week, Ronnie had resigned as HOA president. Within a month, she and her husband were facing multiple civil and criminal charges. Within 3 months, the HOA had dissolved completely, replaced by a new homeowners association run by actual homeowners, not power-hungry bureaucrats. The best part? The boundary line is restored to its original position. The geological features are respected, and the community is finally starting to heal from years of Ronnie's tyranny. But here's what most people don't realize about situations like this. They're not really about land or property lines or even HOAs. They're about respect. Respect for the law, respect for nature, respect for your neighbors. If you're dealing with an HOA that's overstepping its bounds, here's what you need to do. 1. Know your rights. Get a copy of your property deed and the original development documents. 2. Document everything. Keep detailed records of all interactions and violations. 3. Build alliances. Find other affected homeowners who are willing to stand with you. 4. Go to the authorities. File formal complaints with the appropriate regulatory agencies. 5. Stay calm and professional. Don't let anger cloud your judgment or your strategy. Most HOAs rely on the fact that people don't know their rights and won't fight back. But when you do know your rights and you do fight back properly and strategically, you'll find that their power evaporates faster than soil in the rain. This wasn't about revenge. It was about accountability. It was about making sure that Ronnie and her cronies couldn't keep taking advantage of people who didn't know better. And it worked. Not with explosions or dramatic flooding or military engineering, just with knowledge, preparation, and the patience to follow the process. Let me share something I discovered during this process that most people never consider. HOAs operate on the assumption that 95% of homeowners will never read the governing documents. They count on the fact that most people don't know the difference between covenants, conditions, and restrictions, CC&Rs, and the actual development documents that establish the HOA's legal boundaries. When I was reviewing the HOA's financial records during the investigation, I found something astonishing. They had been charging special assessments for projects that had never been approved by the membership. They'd been holding secret meetings where they made decisions that should have required a formal vote. They'd been using funds designated for landscaping to pay for Ronnie's community relations trips to Hawaii. The most brazen violation was how they handled the Architectural Review Committee. They'd created a system where any homeowner who questioned an HOA decision would automatically be flagged for special scrutiny on any future renovation requests. It was a textbook case of retaliation, something that's explicitly prohibited under Washington state law. What really opened my eyes was seeing how the HOA's financial records had been manipulated. They'd created a complex system of shell companies and fake invoices to siphon off money. One company, called Community Enhancement Services, had billed the HOA over $95,000 in the past year. But when I checked with the Secretary of State's office, I discovered that the company didn't actually exist. It was just a P.O. box and a bank account controlled by Ronnie's husband. This kind of financial manipulation is more common than you'd think. A 2022 study by the Community Associations Institute found that nearly 30% of HOAs have some form of financial irregularity, but less than 5% ever face consequences because homeowners don't know what to look for. I want to emphasize something important. This wasn't just about me winning my case. It was about creating a template that other homeowners could follow. After the court ruling, I created a simple checklist for homeowners who suspect their HOA might be overstepping its bounds. I shared it with the other affected homeowners, and within weeks, 3 of them had successfully gotten their dues refunded. Here's what that checklist looks like. 1. Verify your property's inclusion in the HOA. Obtain a copy of your property deed. Get the original development documents from county records. Compare the boundaries in both documents. If they don't match, you may have been improperly included. 2. Review the HOA's governing documents. Request copies of the CC&Rs, bylaws, and articles of incorporation. Check for proper amendment procedures. Verify that all changes were properly approved. Look for clauses that might have expired. 3. Examine financial records. Request the past 3 years of financial statements. Check for unusual expenses or vendors. Verify that special assessments were properly authorized. Look for patterns of late fees or penalties. 4. Document everything. Keep copies of all communications. Note dates, times, and names of people you speak with. Take photos of any violations you observe. Maintain a detailed timeline of events. 5. Know your state's laws. Research your state's HOA regulations. Understand your rights as a homeowner. Find out which agency oversees HOAs in your state. Learn about the complaint process. The beauty of this approach is that it doesn't require legal expertise. It's about systematic documentation and understanding the rules that govern these organizations. Most HOAs collapse under scrutiny because they're built on a foundation of assumptions. Assumptions that homeowners won't read the documents, won't ask questions, and won't stand up for their rights. I received a message last week from a woman in Seattle who used my checklist to challenge her HOA. They'd been charging her $350 a month for common area maintenance on a property that was explicitly excluded from the HOA in the original development documents. She followed the steps, filed a complaint with the appropriate agency, and within 2 months, she'd gotten 2 years of dues refunded, and the HOA was under investigation. That's the power of knowledge. That's why I'm sharing this story with you today. One thing I want to address directly is the fear factor. Most people are afraid to challenge their HOA because they're worried about retaliation, higher dues, more fines, or even a lawsuit. I get it. When Ronnie first showed up at my door, I felt that same knot in my stomach. But here's what most people don't realize. HOAs are incredibly risk-averse. They're made up of homeowners just like you, and they don't want negative publicity or legal trouble any more than you do. When you approach the situation with documented facts and a clear understanding of the law, you shift the power dynamic. Suddenly, it's not about whether you can afford a lawyer, it's about whether the HOA can afford the negative attention and potential legal consequences of continuing their improper practices. Another common misconception is that you need a lawyer to challenge an HOA. In many cases, you don't. Most states have laws that require HOAs to make their governing documents available to homeowners. The agency that oversees HOAs in your state often provides free resources and guidance. Let me share a story that illustrates this point. After my case was settled, I got a call from a neighbor who'd been living in Pine Ridge Estates for 25 years. She told me that for the past 20 years, she'd been paying $200 a month in HOA dues, believing it was mandatory. When she checked her deed after hearing about my case, she discovered that her property was also exclusively excluded from the HOA. She went to the HOA board meeting and calmly presented her documentation. The board chairman tried to intimidate her, but she stood her ground and cited the specific Washington state statute that protected her rights. Within a week, she'd gotten all her dues refunded going back 20 years. That's over $48,000. That's the power of knowing your rights. I want to address something else that's important: the emotional toll of these battles. When Ronnie first started harassing me, I'll admit, I felt isolated. I wondered if I was the only one who saw what was happening. I questioned whether I was overreacting. That's exactly what HOAs count on. They create an environment where questioning authority feels like being a bad neighbor. But here's the truth: standing up for your rights doesn't make you a bad neighbor. It makes you a responsible community member. A community where people are afraid to question authority isn't a healthy community. It's a community ripe for abuse. When I was preparing for the court hearing, I made a conscious decision not to let anger drive my strategy. Anger makes you sloppy. It makes you emotional. It makes you lose sight of your objectives. Instead, I focused on the facts, the documentation, and the law. I treated the whole process like I would treat a geological survey, systematically identifying vulnerabilities and addressing them one by one. This approach served me well in the courtroom. While Ronnie's attorney was making dramatic gestures and using emotional language, I was calmly presenting my evidence, citing specific statutes, and letting the facts speak for themselves. The judge responded to that professionalism. Here's something else I learned that might surprise you. Most HOA board members aren't bad people. They're often well-meaning homeowners who've been misled by previous boards or by HOA management companies. The real problem is usually the small group of power-hungry individuals who dominate the board and set the tone for everyone else. In my case, Ronnie was the driving force behind the improper boundary adjustment. The other board members were just going along with it because they trusted her. When the evidence came out in court, several of them looked genuinely shocked. One even approached me afterward to apologize. That's why I always recommend starting with a conversation, not a confrontation. Go to an HOA meeting, ask questions about the governing documents, and request copies of anything you're unsure about. Most of the time, the issue can be resolved with a simple clarification. It's only when you're met with resistance or evasion that you need to escalate. I've heard from dozens of viewers since I started sharing stories like this, and the pattern is always the same. Someone challenges their HOA with documented facts and a clear understanding of the law, and the HOA backs down immediately. They don't want the scrutiny. They don't want the paperwork. They certainly don't want the potential legal consequences. This wasn't about revenge. It was about accountability. It was about making sure that Ronnie and her cronies couldn't keep taking advantage of people who didn't know better. And it worked. Not with explosions or dramatic flooding or military engineering, just with knowledge, preparation, and the patience to follow the process. Where are you watching from? Drop a comment below and tell me your HOA story. I read every single one. If you're dealing with an HOA that's overstepping its bounds, I'll give you the same advice I'd give a friend. Don't panic, get the documents, know the law, and fight smart. Hit subscribe if you want more stories about taking on bureaucratic bullies and winning. Next week, I'm telling you about the time I took down a corrupt property management company by finding a single missing comma in their contract. That's a story about how the smallest details can bring down the biggest empires. Your voice matters. Your property rights matter. And sometimes, all it takes is one person willing to stand up and say no more to change everything. Pine Ridge Estate's boundary lines are restored, y'all, and they always will be. Let me share something else I discovered during this process that most people never consider. Land boundaries aren't just lines on a map, they're part of a larger ecological system. The glacial moraine that defined my boundary wasn't just a convenient landmark, it was part of a watershed that affected the entire community. When Ronnie tried to ignore this natural feature, she wasn't just violating property laws, she was disrupting the natural water flow that affected drainage, soil stability, and even local wildlife patterns. The heavy rains that caused the soil instability weren't an act of God, they were the direct result of ignoring the natural landscape features that had been carefully documented for over a century. This realization led me to work with the local environmental groups to create a watershed protection plan for the entire community. We mapped out all the natural features, the ridges, valleys, waterways, and used them to establish boundaries that respect both property rights and environmental needs. The result? A community that works with the land rather than against it. Drainage problems that had plagued the neighborhood for years were resolved. Property values increased as the natural beauty of the area was preserved. And most importantly, the community became more cohesive as neighbors worked together to protect their shared environment. This is something I wish more people understood. Property rights and environmental stewardship aren't opposites. They're two sides of the same coin. When you respect the natural features of your land, you're not just protecting your property, you're protecting your community. Another lesson I learned is that bureaucracy moves slowly, but nature moves according to its own timeline. When Ronnie tried to force the boundary adjustment through the HOA process, she was working within the slow, methodical pace of human bureaucracy. But the land itself was operating on geological time, slow but inevitable. The heavy rains that exposed the boundary violation weren't an accident, they were the result of ignoring the natural drainage patterns that the glacial moraine had established over thousands of years. When Ronnie tried to redraw the boundary without considering these patterns, she set in motion a chain of events that the land itself would correct, with or without human intervention. This is a powerful lesson for anyone dealing with HOA overreach. Nature has its own way of enforcing boundaries. Whether it's water finding its natural course, soil following its natural contours, or plants growing where they're meant to grow, the land itself will eventually assert its true nature. Sometimes, all you need to do is wait for the land to speak for itself. I also discovered that many homeowners don't realize they have rights beyond what the HOA tells them. Most people think that once you join an HOA, you give up all control over your property. That's not true. HOAs have limited authority defined by state law and their governing documents. They cannot override property rights, ignore natural features, or impose fines without following due process. One of the most powerful tools I discovered was the concept of senior rights. These are rights that existed before the HOA was formed and that cannot be overridden by HOA rules. In my case, the boundary lines established in 1902 were senior rights that predated the HOA by over 60 years. No HOA rule could change those boundaries. This concept applies to many other situations. If your property has senior water rights, mineral rights, or conservation easements, those rights cannot be overridden by HOA rules. Many homeowners don't even know these rights exist until they're threatened. I've made it my mission to educate other homeowners about their senior rights. I've given talks at community centers, written articles for local newspapers, and even started a podcast where I interview experts about property rights and land stewardship. The response has been overwhelming. People are hungry for this information. They want to know their rights, but they don't know where to start. My message is simple. Start with your property deed. Read it carefully. Understand what rights you have. Then, if those rights are threatened, stand up for them. One of the most rewarding parts of this experience has been seeing how it's inspired others to take action. After my case was settled, I started receiving messages from people all over the country who were dealing with similar HOA overreach. Some were able to resolve their issues with the simple checklist I shared. Others needed more help, so I connected them with resources and experts in their area. The most inspiring story came from a woman in Colorado who used the same approach to challenge an HOA that was trying to fine her for having a native plant garden. She documented everything, built a coalition of like-minded neighbors, and went to the authorities with clear evidence. Within 3 months, she'd not only gotten the fines reversed, but had also changed the HOA's landscaping rules to be more environmentally friendly. This is the power of knowledge. When one person stands up for their rights, it creates a ripple effect that can change entire communities. I've also learned that timing is everything. In my case, the heavy rains that exposed the boundary violation came at the perfect moment, just as Ronnie was about to finalize the boundary adjustment and impose the $70,000 fine. It wasn't luck. It was the result of careful observation and understanding of natural patterns. If I had acted too soon, I might not have had the evidence I needed. If I had acted too late, the boundary adjustment might have become much harder to reverse. By understanding the natural cycles of the land, the rainy season, the soil stability patterns, the seasonal changes, I was able to time my actions perfectly. This is something I share with anyone facing HOA overreach. Understand the timing. Don't rush into action, but don't wait too long either. Observe the patterns, both natural and bureaucratic, and act when the time is right. Another important lesson is that documentation is your most powerful weapon. Throughout my battle with the HOA, I kept meticulous records of everything: dates, times, names, conversations, photos, videos. This documentation became my evidence when I needed to prove my case. Most people don't realize how important documentation is until it's too late. They assume that common sense or fairness will prevail. But in legal matters, it's the evidence that matters. If it's not documented, it didn't happen. I've developed a simple system for documenting HOA interactions that I share with everyone who asks. Keep a dedicated notebook for HOA matters. Record the date, time, and location of every interaction. Note the names and positions of everyone involved. Write down exactly what was said. Take photos or videos whenever possible. Save all emails, letters, and other written communications. Create a timeline of events. This system has helped dozens of people successfully challenge HOA overreach. It's simple, but it's incredibly effective. I've also learned that community is your greatest ally. When I first started challenging Ronnie, I felt isolated and alone. But as I began talking to my neighbors, I discovered that many of them had similar experiences. Together, we were much stronger than any of us were alone. This is why I always encourage people to build alliances with their neighbors. Find others who are facing similar issues. Share information and resources. Support each other through the process. There's power in numbers, and HOAs are much less likely to target a group of organized, informed homeowners than they are to target a single individual. One of the most important things I've learned is that this isn't just about property rights, it's about community. A healthy community is one where people respect each other's rights, work together to solve problems, and create a place where everyone feels welcome and valued. When HOAs overreach, they don't just violate property rights, they damage the sense of community that makes neighborhoods special. By standing up for your rights, you're not just protecting your property, you're protecting the community you live in. This is why I continue to share my story and help others facing HOA overreach. It's not just about winning individual battles, it's about creating stronger, healthier communities for everyone. Where are you watching from? Drop a comment below and tell me your HOA story. I read every single one. If you're dealing with an HOA that's overstepping its bounds, I'll give you the same advice I'd give a friend. Don't panic, get the documents, know the law, and fight smart. Hit subscribe if you want more stories about taking on bureaucratic bullies and winning. Next week, I'm telling you about the time I took down a corrupt property management company by finding a single missing comma in their contract. That's a story about how the smallest details can bring down the biggest empires. Your voice matters, your property rights matter, and sometimes all it takes is one person willing to stand up and say no more to change everything. Pine Ridge Estates boundary lines are restored, y'all, and they always will be.